All right. Hey, everyone. Welcome to today's webinar. We're talking about protecting yourself in small business bankruptcies. I'm Mike Fielding. Co-presenting with me is Yana Vladimirova. I'm in our Kansas City office, and Yana's up in our Madison, Wisconsin office. Just a couple of housekeeping matters I need to cover. Need to read this script here for you all, so bear with me. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We will try to answer all questions during the webcast today, but if a fuller, bigger answer is needed, we'll follow up with you following the webinar today. We'll do it via email. A PDF of the presentation is available in the program's material folder, and that's just going to be a PDF of our PowerPoint that we have here. This program has been approved for legal education hours. For live attendees, you will report your hours by clicking on the CEU icon at the bottom of the screen, and then a certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. I'm sure it will not interest your teenagers, as it wouldn't interest mine. Anyway, toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs, and I will say the feedback we've received in the past is really invaluable, and we really do appreciate any insight. All that.
Hello, everyone. I believe Michael froze temporarily. We'll just give him a minute to refresh. It is, I guess I can start us off. I'm covering the first few slides anyways, so I'll just go ahead and start. I will start with an overview of Subchapter 5 by first going through the numbers and specifically the numbers of filings compared to regular Chapter 11 since Subchapter 5 was first introduced. I will then talk about how Subchapter 5 is different than a regular Chapter 11 and also how it is similar than a regular Chapter 11. And then I will also tell you a little bit about the role of a Subchapter 5 trustee. I am a Subchapter 5 trustee myself, and the role of a Subchapter 5 trustee is oftentimes a little bit different than other bankruptcy trustees. So starting with the numbers, as you can see, in the short time frame, Subchapter 5 has been in effect. Its popularity has only grown. In fact, in the first quarter of 2022, Subchapter 5 cases represented the majority of Chapter 11 filings. And there are, of course, several reasons for that. Of course, first of all, Subchapter 5 is quite beneficial to debtors, as we will see. And that's because it is faster than a regular Chapter 11, it's cheaper than a regular Chapter 11, and Subchapter 5 debtor can push through a plan even if all creditors object. But also the timing of when Subchapter 5 came into effect is not to be ignored. The law was enacted in the summer of 2019, but it became effective in February of 2020, just a month before COVID took a hold of the country and the world. And with that, Congress increased the original debt cap. And this means that one of the requirements originally for filing under Subchapter 5 was for debtors to have total debt of no more than 2.7. But with COVID, Congress increased that number to 7.5 million, or almost 3 times as much debt debtors were able to have, which of course made a lot more debtors eligible to file under Subchapter 5. That increase was originally just for 1 year, which was then extended for another year, and now it's a permanent fixture of Subchapter 5 cases. So that's certainly a big reason for why Subchapter 5 has been so popular, in addition to all the benefits it provides debtors. Now to the law itself. As I said, Subchapter 5 was enacted in the summer of 2019. It was a result of a bipartisan and bicameral effort, and was aimed at addressing a long-standing problem with small businesses, which in the past not only did not succeed in Subchapter 5 in Chapter 11 cases, but avoided filing them altogether. And the reason for this was the absolute priority rule, which is a requirement in the Chapter 11 case, but not a requirement in the Subchapter 5 case. And the absolute priority rule basically states that the owners and shareholders of a company cannot retain their ownership interest unless all creditors are paid in full. And in a small business, the shareholders or the owners are oftentimes the same people who started the business and the people who manage the business. So for them, filing a regular Chapter 11 was simply not attractive. So one of the greatest benefits to a Subchapter 5 case is that the absolute priority rule is no longer in effect, and debtors can propose a plan where they don't pay creditors in full and still retain some of the their ownership interest. So what else is different in a Subchapter 5 case? Quite a bit, actually. One of the biggest differences is that debtor has to propose a plan within 90 days from filing the bankruptcy petition. And only the debtor can propose a plan. In a regular Chapter 11, there is no such requirement, except for the requirement that only a debtor can propose a plan in the first 120 days of filing. But otherwise, other parties can also propose a plan in a regular Chapter 11. And because the plan has to be proposed so fast, the court holds what is called a status conference within 60 days of filing. And the reason for the conference is really for the court to check with the debtor and make sure that the debtor is on track to propose a plan within the 90 days. And courts generally do not like to extend that timeline, at least based on the cases that we have seen so far. Another difference is that there is no creditor committee in a Subchapter 5 case, which means that unsecured creditors are not protected as well as in a Chapter 11 case. No disclosure statement is required either. As a reminder, disclosure statement is required in a Chapter 11 case, and a disclosure statement generally provides a little more information for creditors to understand the reason for the bankruptcy filing and the debtor's plan going forward. There are also no quarterly U.S. trustees fees, which has been cited as a reason for why Subchapter 5 cases are cheaper. That, of course, is not always true because the debtor has to pay the Subchapter 5 trustee. And depending on how complex a Subchapter 5 case gets, those fees can be substantial as well. It is also much easier to confirm a subchapter 5 case than a chapter 11 case. And there are generally two ways a subchapter 5 debtor can propose a plan. One way is consensually, meaning that all creditors agree to the plan. And the other way is non-consensually, meaning that none of the creditors really need to approve the plan. Compare this to a Chapter 11 case. In a Chapter 11, a debtor cannot really propose a plan, have a plan confirmed if the majority of an impaired class does not agree to the plan. Moving on to the next slide. Again, as I said, the absolute priority rule does not apply in a subchapter 5 case. And administrative expenses do not need to be paid at confirmation, as in a regular Chapter 11. They can be paid through the plan, again, because the debtor can really propose a plan where no creditors agree to their treatment. The debtor only has to pay disposable income for 3 to 5 years. If a plan is proposed consensually and confirmed consensually, the debtor gets a discharge at confirmation. And if it's proposed non-consensually, the debtor gets a discharge once all plan payments have been made. And again, because of the absolute priority rule, the debtor retains ownership of assets. Now to the role of the subchapter 5 trustee. Again, this is not similar to any other bankruptcy trustee role, but it's probably most similar to Chapter 12 and 13 trustee. Generally, subchapter 5 trustees are not operating trustees unless the debtor is removed as a debtor in possession due to fraud or mismanagement of the business. But outside of that, the subchapter 5 trustee's role is really to supervise the restructuring process, advise the court as needed, review financial information, and I guess the most important role of the subchapter 5 trustee is to facilitate the consensual plan of reorganization. And the reason for that is a consensual plan of reorganization provides many benefits, not only to the debtor, but to everyone, because at confirmation, the subchapter 5 trustee is discharged, meaning that the expense of having a subchapter 5 trustee is no longer in play, and that generally makes the case cheaper. So this is one of the main roles of the subchapter 5 trustee. What remains the same in a subchapter 5 trustee? The automatic stay is still in effect, which means that creditors cannot continue with their collection efforts in violation of the automatic stay. Debtors still need to provide adequate protection to their secured creditors. The debtor still remains as a debtor in possession and continues the operation of the business. If the debtor seeks post-petition financing, it needs to get an approval from the court. Section 363 sales are still an option, and they can be approved by the court. And the debtor can reject or assume a contract under the bankruptcy code. And finally, the Section 523 discharge exceptions are still in effect. And some examples of that is debts incurred due to fraud, and so on. Okay. So the subchapter 5 case is beneficial to debtors, but not necessarily so to creditors. Again, that's because the debtor can propose a plan even if all creditors object to it. So what are some ways creditors can fight against the subchapter 5 case? The first line of defense is challenging the eligibility of the debtor to file under Subchapter 5. Most courts have held that the debtor bears the burden of proving Subchapter 5 eligibility. And some of the requirements for Subchapter 5 are, as I already said, the debtor has to show that the total debt is no more than 7.5 million. Must be a person, also it can be a corporation. So it can be, a Subchapter 5 can be an individual case, and it can be also a business corporate case. The debtor has to show that it's engaged in commercial and business activities. And I'm going to talk about a case that recently came down where a court interpreted what exactly this means. It cannot be a single asset real estate, which means that businesses which are hotels or bed and breakfasts cannot generally file under Subchapter 5 if they don't have other business activities. More than at least 50% of the debt has to come from commercial or business activity. And that generally applies to individual debtors who have not only business debt but individual debt as well. Then also, if a debtor is one in a group of affiliated debtors, the debt cap as a whole in aggregate cannot exceed 7.5 million. And finally, a debtor may not be considered an issuer of securities under the SEC. So, as I said, just a second, courts have already started addressing some of these requirements. So with respect to whether the debtor can be an issuer, a California bankruptcy court recently held that the requirement as to an issuer is not only for publicly traded companies, but also to privately held ones. And that was not very clear from the language of the bankruptcy code. So now that is clarified that it applies to also privately held businesses. With respect to the debtor needing to prove that it's engaged in commercial and business activities, several courts have opined on this, and the general consensus is that this requirement is quite broad. For example, a court in the Ninth Circuit recently held that a debtor does not need to have even a profit motive to be eligible for a Subchapter 5 case. In that particular case, the debtor didn't have any employees for a few years before filing bankruptcy. He didn't have any profit or revenue for a few years before filing bankruptcy. And was not really in the traditional sense engaged in commercial or business activity. And the court still found that the requirement is very broad and the debtor and allowed the debtor to proceed under Subchapter 5. If this first line of defense fails, the creditors still have the option to move for the case to be dismissed or converted to a Chapter 7 for cause. Generally, any party in interest may seek this remedy. In deciding whether to dismiss or convert a case, courts generally utilize the best interest of creditors and the estate test, which means that the courts look into what will happen if the debtor's assets are liquidated, what distributions creditors will have. But it also looks into, what will happen to employees if a case gets converted and the business is no longer in operations. So it weighs all of these pros and cons of conversion. So in a conversion may be beneficial in a case where the debtor has a lot of assets that, when liquidated, can bring in larger distributions to creditors, versus in a situation where the debtor does not have many assets that can be easily liquidated. It is more likely that it will be more beneficial for creditors for the debtor to stay in bankruptcy and generate revenue and pay creditors in a different way. In the dismissal scenario, this basically means that the debtor is no longer going to be in bankruptcy and creditors can go after the debtor. The automatic stay then goes away and the creditors can go after the debtor through state and federal court and try to get paid on their claims. Again, parties in interest which seek dismissal or conversion have to establish cause, and there is a pretty long list on the section 1111B, 1112 of what constitutes cause, and some of those examples include substantial or continuing loss to the estate in the absence of a reasonable likelihood of rehabilitation, gross mismanagement of the estate, failure to maintain insurance, unauthorized use of cash collateral that is substantially harmful to a creditor, unexcused failure to timely comply with reporting and filing requirements, and the list goes on. And it's not a exclusive list. There are other reasons that creditors can point to when they ask for the case to be converted or dismissed. And with that, I'll pass it back to Michael, who will tell us about DIP financing.
I'm back from my technical difficulties earlier. It's funny, haven't had many since the pandemic began, and then all of a sudden right here and now. All right, so when we're doing this debtor-in-possession financing, DIP financing, we're making the assumption that debtor's going to clear the eligibility hurdles. And I know the vast majority of folks on our call today work at lenders, so I think this will be a really important little segment here. This is segment number 3, where we're talking about debtor-in-possession financing. The first thing I want to say, what I would call my number 1 rule of thumb, if you are a bank and if you have a small business that is looking to file, or maybe they have filed unexpectedly, and they come to you, say, hey, we want debtor-in-possession financing. Should you do it or should you not? And my number 1 rule of thumb is, can they cash flow, with the automatic stay in place and still be able to service secured debt? If the answer to that is yes, then they probably are a good candidate for debtor-in-possession financing. If the answer is no, then, why would you throw good money after bad? They wouldn't be a
Hello again. Michael, it appears that he still has technical difficulties, so we're going to skip a little ahead. I'm really sorry about that. It is not what we expected happening. But I'm going to talk a little bit about the 1111B election. The 1111B election, just trying to skip here. Oh, Michael is.
Yeah,
Michael is
Donna,
back.
I apologize. I don't know what's up. I have not had difficulties like this. I do not know what's up. Folks, I really apologize for this. This is hugely embarrassing, but we'll keep plugging along here. The one thing on the prior slide, I just wanted, or past couple of slides, and I want to mention this. Last year, I did a really deep academic article. I was really interested in resolution of distressed debt, and I looked at a lot of the academic literature looking at debt financing. And what, in a nutshell, what the academic literature says is that if borrowers, debtors get debtor-in-possession financing, they tend to have quicker bankruptcies, and they tend to be able to more quickly reorganize. And when you look at that, again, big picture, grand scheme of things, if you have a really bitter, contested bankruptcy, that's going to just churn and burn your attorney's fees the longer it drags out. If you can shrink the duration of that bankruptcy, which is what Subchapter 5 is intended to do, you can then get even fewer attorney's fees and hopefully get on a path to profitability. Now, sometimes you're put into a situation where they just file and it's unexpected, and we don't like that because we didn't see it coming. And the question is, well, how do we as a lender protect ourselves and our cash collateral? Now, there's so the general rules are up here on the screen, and the general rule is that a debtor can do what are quote unquote ordinary course transactions. So if they have a business, they're just buying and selling, they can do that without any court approval, unless you get into a couple of situations. First, the debtor can't use cash collateral unless the lender consents, or the court has to authorize the use of that cash collateral. The reason that becomes important is because we as lenders don't want these debtors who've been typically irresponsible to some degree. We don't want them going out there willy-nilly just spending cash and, frankly, burning down collateral that secures the bank's lien. So what do you do to protect yourself? You can see up here the best practices. What I always like to do is when we get the bankruptcy filed, I immediately file this notice of non-consent to use of cash collateral. And what I'm doing is putting the world on notice that we're not consenting to the use of cash collateral. That then puts into practice a chain of events, because if the debtor wants to use cash collateral for business operations, it has to run to the court to get approval, but the debtor also has to run to you as a lender to see if you can strike a deal. Now, this is where when you get into the situation, it really depends on the particular facts and circumstances of the case, because if the debtor can truly give you adequate protection so that your debt level, the collateral securing you, it's not going to diminish, it may make sense because you keep the debtor alive by giving it the use of the cash collateral. The one thing I will say is that bankruptcy judges, by and large, tend to be biased towards the debtor at the very beginning of the case. And when I say biased towards the debtor, they are biased towards giving the debtor a chance while in bankruptcy. And so you need to keep that in mind as you're dealing with it, so that you can try to be reasonable in your negotiations with it. Now, let's shift over here to the the different tiers of financing. And this is where we're getting into the debtor-in-possession financing and the protection that you as a lender are going to want to get. Now, these tiers of financing, you can see them up on the screen. There's really 5 tiers. Tier 1 is, you just get an administrative expense priority claim, which why on earth would you ever want to do that? You don't want to have an unsecured admin claim. Tier 5 is the super priority priming lien, which is the golden standard to get, but it's kind of difficult to get. Now, what you'll see here are the priming liens if we want to get to tier 5. And in each of these different tiers, the debtor has to show it wasn't, if the debtor is trying to get like tier 3, it has to show it couldn't obtain tiers 1 and 2. So that burden of proof is there. But when we get into the priming lien situation, the debtor has an additional burden to show that the lenders whose liens are being primed, that they are adequately protected. So translation, when you think that through, there's a practical issue associated with that, and these priming liens are very difficult to obtain. Now, that being said, lenders, DIP lenders come in, will try to get them. So let's step back and look at this. If you are a pre-petition lender and somebody's coming in and you're done with them, you're not going to deal with them anymore, but they found somebody else that wants to come in and do a debtor-in-possession loan, and there are definitely companies that will come out there and do that, you have to be really alert and vigilant as a lender at the beginning of the case to make sure your liens are not getting primed. The flip side to that is that maybe you want to come in and do the loan, and if you want to do that, and if you want to get this Tier 5 super priority protection, then what you're going to have to do is look and see, is there collateral, excess collateral, or equity cushion that we can say protects these pre-existing lenders. Typically, the most common scenario for that is if you have real estate where there's a fat equity cushion in it. That's typically the easiest one to go to. When you get into personal property collateral, I get a little bit more skeptical on that because, you know, anybody that's dealt with personal property collateral issues knows how precipitously the collateral value can fall. Now, the next couple of slides here are really important when we talk about the roll-up of debt, because what we're trying to do, you can see there the general rule is that your pre-petition debt can be subject to cram down. Let's say that you are owed $3 million and the collateral is only worth $2 million. So if we keep the status quo, if they go through bankruptcy, they would confirm a plan, and suddenly that $3 million debt gets split into two parts. You have a $2 million secured debt and then a $1 million unsecured debt that gets paid the same pro rata distribution as general unsecured creditors. Lenders hate that scenario. So what do we do to try to avoid that? Well, you get into the question of, can we do some sort of roll-up where we convert pre-petition debt into secured debt? And the reason why post-petition secured debt is beneficial is because you can't do cram down on post-petition debt across the board. That's the rule. And so if we can get into that category, then we're protected as a lender. Now, there's two different ways you can do that. You'll see that here on the screen. There's the lump sum approach or a creeping approach. The lump sum approach is you just come in and say, okay, we see that there was $3 million owed. Guess what? We're going to do a $3 million post-petition loan. We're going to pay off the pre-existing debt. We're going to collateralize this post-petition note with all your assets, you know, give us all the bells and whistles and protections, and we would be good to go. Now, the key thing on the lump sum post-petition payment is that typically courts are going to require that you're adding or putting in new monies as part of that lending facility. And I realize that may be a really hard swallow in a lot of loan departments to do something like that. You may not want to do that. And you may just be back in the what I'll call the adequate protection treading water arena, where we're not going to really advance new monies. We'll let them to continue to, you know, run their business and use AR and whatnot, but we're not going to advance monies. That's really kind of a case-by-case decision. The other option that you have for the roll-up of debt is what's called this creeping debt, and this is where you get they get a line of credit, and then anytime they collect monies and pay it to the bank, those monies that are received are used to pay down the pre-petition debt. And then obviously when they're making draws post-petition on the line of credit, that's a post-petition debt. So you can see that over time with a revolver, especially if this plays out long enough, the entire pre-petition debt can be extinguished, and then you have this post-petition revolver. The problem with that is that, you know, it works great in the big mega cases where you maybe have a 1-year term revolver and they're going to be in bankruptcy for 18 months. The problem is in the subchapter 5 arena, we have 90 days to get a plan confirmed. There's no deadline once they propose a plan, they have that 90-day limit. And so it could drag on a little bit, but you can just see the practical math of a revolver. You're typically not going to do the revolver an entire year's period of time. All right, now the next three slides really get into some key provisions that you will want to have in your DIP agreements. And when you think about a debtor-in-possession finance agreement, it happens at the very beginning of the case. But this is a really important hinge point, because if you do your DIP finance agreement correctly, it's going to really set the shape, tone, and tenor of the remainder of the case, certainly with respect to the debtor, but it will play a huge role in what the final plan is that the debtor confirms. And so you can see how critical it is that in a perfect world, if you get wind that your borrower is going to be filing a subchapter 5 bankruptcy, or they're seriously thinking about it, you actually want to start having these discussions before they file for bankruptcy. And in a perfect world, in an ideal world, what you would do is you would get this debtor-in-possession financing agreement in place, and then they file, and then you file this, make this part of your day one filing. That then sets the trajectory for the plan that gets confirmed. Now you can see the different items that we want in here. Your admissions are critical. We're looking at this not only for getting our loan protected, but we want evidentiary admissions in case we ever get into any litigation down the road if things spin out of control with the debtor. You want your, obviously your post-petition liens. Budgets are super important. We want to make sure that they have a strict budget, that they have to stay within a reasonable variance of that budget, and then deal with that. Other provisions that you'll see right here, I don't need to go through all these. They're pretty self-explanatory. The bottom bullet point, though, is liens on Chapter 5 causes of action. Now that's these clawback actions, preferential transfers, constructively fraudulent conveyances. Nobody likes them. But they are a potential source of revenue. So if you are putting new money into the debtor as part of your DIP financing, you'll want to try to get a lien on those Chapter 5 causes of action. And then the last item right here is keep in mind that you are negotiating with the debtor in possession. Yes, people like Yana are there serving in the role of the subchapter 5 trustee, and it's more of a supervisory role, but you're really negotiating with the debtor. Now, things could spin out of control with this debtor, and things could go south, and it could be that the case ultimately converts and you get a Chapter 7 trustee, somebody who comes in and is now controlling the debtor. And the reason it's important that when you're negotiating these DIP financing agreements is we want to get releases and waivers of, frankly, every potential claim that the debtor would have against the lender, right? It makes common sense. And we especially on this last bullet point, and it's iffy in the Eighth Circuit, but if the case converts to Chapter 7 and then a trustee goes out and just liquidates everything, we'd like to have that surcharge right waived. And to give you an example of how that plays out, there was a case that just came out last week out of Texas, and it was a sale of assets. The lender was going to credit bid, and the trustee proposed and said, hey, even if the lender credit bids, the lender has to come out of pocket and pay a 3% buyer's premium, cash out of pocket. Now, you know that doesn't go well in loan departments when you hear something like that, but the bankruptcy court sustained that, what the trustee was asking for, because the bankruptcy court was of the opinion that the trustee had the right to surcharge the estate because this was a benefit for the lender. All right. So that's why if we can get the waiver of the 506C surcharge, we can avoid problems like that down the road. All right. Now I've been beating that horse to death, so let's go on to 363 sales. Fortunately, this is a single slide here, so we'll be quick on the 363. A 363 sale, that is named for a section in the bankruptcy code. And what that does is it allows sale of assets free and clear of these liens and encumbrances. Now, there are some important considerations. Are we selling all the assets? Are we selling part of the assets? Do we do it as a separate standalone 363 sale and then do a plan of reorganization? Or do we try to merge it all together so that as part of this plan of reorganization, the assets get sold. And the big question at the end of the day is, how are creditors going to fare under this? Now, to give you an illustrative example, last year I represented the debtor, and I know that sounds like heresy, right? I typically represent lenders in all that I do, but occasionally I dip my toe in and I'm asked to represent a debtor. And last year I was asked to represent a debtor out in Nevada on a bankruptcy, and they had a large amount of debt, large claims, or a couple of $1 million in estimated claims initially is what they thought it potentially could be. Filed claims didn't end up being anywhere near close to that, but what we did is ended up filing the bankruptcy, found a purchaser, and then we just confirmed the plan and then sold all the assets as part of that plan of reorganization, with some cash coming in to pay off the secured lender. And then there were some residual assets left with the debtor that would be liquidated and used to pay unsecured creditors. So there's definitely a time and place for this, especially if you have somebody else that wants to come in and acquire the assets. But again, I think it's important that these 363 sales be done through negotiations with the lender, with the borrower, with the third party, so we know and make sure that the lender is going to get as much of its collateral paid for as it can. All right, Yana, you want to talk about the 1111B election?
Sure. So the 1111B election is a section of the bankruptcy code that technically allows undersecured creditors to get paid in full on their claim. Without the election, undersecured creditors in bankruptcy generally don't. And this is because undersecured claims are bifurcated into two separate claims: a secure claim for the value of the collateral that secures the claim, and an unsecured portion for the remainder of the claim. And in most cases, the unsecured portion of the claim gets very little to nothing in distribution. And subject to two exceptions, Section 1111B allows a secured creditor who is undersecured to elect, instead of having its claim bifurcated, to entirely relinquish its unsecured claim and have its entire claim treated as a secured claim and paid over an extended period of time. And when I say an extended period of time, this means 10, 20, 30 years. The election has not been very popular in regular Chapter 11 cases because oftentimes it is more advantageous for a secured creditor to keep its bifurcated unsecured claim. And this allows an unsecured creditor to maintain its status as an impaired creditor, and it gives the creditor the ability to block on an unfavorable plan confirmation under Section 1129A10. But in the Subchapter 5 case, this blocking advantage of an unsecured claim is wanted because the debtor may confirm a plan, as I already said several times, even if no class of creditors accepts them. As a result, some unsecured creditors have been opting to elect 1111B treatment, and this has become the subject of a few bankruptcy decisions. One of the exceptions, I mentioned that there are two exceptions to the 1111B election, and one of those exceptions is that the creditor, I guess the debtor can object to the election by saying that the value of the collateral is of inconsequential value, which means that in simple terms that the value of the collateral is too small in relation to the total claim. So to give you an example, there was one of the first cases to look into the 1111B election in the context of Subchapter 5 cases was a case from the Second Circuit, a New York case, where the debtor operated several fitness facilities, and in that case, the value of so the secured creditor was basically the creditor who provided the fitness equipment, and the value of the fitness equipment was estimated at approximately $90,000, while the total claim was approximately $500,000. And in that case, the court concluded that the value of the collateral was inconsequential, but didn't really utilize any particular test to get there. But basically said that subchapter 5 cases were really not intended for having an 1111B election, because they were meant to make filing a subchapter 5 case easier for debtors. And therefore, the 1111B election really did not belong in subchapter 5. But then another case came from California, and in that case, the numbers were somewhat similar to that Second Circuit case, but there the court said that if Congress did intend for to not have an 1111B election in subchapter 5 case, it would have said so, and allow the creditor to elect treatment of its claim on the 1111B. And then several more cases came that agreed with the California case. So in other words, depending on in which jurisdiction the case is, it is quite advantageous for unsecured creditors to elect 1111B treatment. And even if it's not ultimately something that they win on, it gives creditors quite a bit of leverage in negotiating plan treatments, because debtors generally do not want to have to deal with an 1111B election and pay on a claim for 10 years or more. Yep, and with that, I will pass it back to Michael, who will tell us about how else you can leverage plan confirmation to your benefit as a creditor. Michael, you're muted.
I am having all sorts of technical problems today. I apologize. It's maybe we had COVID blow through the family last week, and so we're in quarantine. I don't think I got it. I hope I'm not having COVID brain here, COVID fog. Anyway, the key thing is these cases move fast, and it's a really important kind of practice, rule of thumb, whatever you want to call it, is you need to start negotiating early. The earlier you can do that, the better. The problem is obviously you can't negotiate everything. Sometimes there might be a few other creditors that have a big influence on the borrower, and it gets a little bit complicated. But you want to try to come in there and kind of create a pivot point, a base. Maybe you put the lending facility in place, what it will look like going forward. And then once the debtor has kind of that base, that reliable base to sustain its business on, then it has really a path forward to deal with maybe unsecured creditors who, frankly, may be a bit of a pain to deal with. Now, we're going to talk about on this slide and the next slide 1191A and 1191B plan confirmation. And you roll your eyes when you hear that, okay? But this is actually really, really important. And the reason for that is these sections 1191A and 1191B, they come from the bankruptcy code. And 1191A is where all the classes of creditors consent to the plan. 1191B is where there are dissenting classes and the judge just says, good enough, we're confirming the plan, okay? Now, the reason this becomes important is because the treatment of the debtor is really, really different. And in the right situation, an 1191A confirmation may be a lot more advantageous to a lender than 1191B. You can see up here the big highlights that I've put on there. From my perspective, the biggest benefits of an 1191A plan confirmation is the debtor is locked into place. It can't modify the plan. The automatic stay terminates. You are off to the races. It's as if the bankruptcy is done and you're moving on. And there is some real benefit in that because we're ending the burn on attorney's fees, we're ending the uncertainty, we're just moving on. The contrast to that is 1191B, and 1191B is where, again, as I said, you don't get everybody consenting to it. And if you've ever been in one of those interminable Chapter 12 cases or interminable Chapter 13, where the debtor gets a plan and then they kind of mope along for a year or two and they miss payments and then they have to go back and amend the plan. And it just feels like, what on earth are we doing? It's this bad credit. It's, we're only getting paid maybe half or 2/3 the time. We can't foreclose because the judge keeps granting them more, more benefit of the doubt. Again, I feel your frustration there, and it's very real. But that's what you get in the 1191B plan confirmation scenario. Trustee is going to stay in place 3 to 5 years. The debtor can modify the plan. So again, we can't always steer into an 1191A confirmation, but if you get into the negotiations and you have that ability to, based on the concessions that you give, sometimes there may be some real long-term benefit to doing that. Now, this challenging the disposable income, this can be a plan objection, but this can actually really be a way to really help the debtor if we're trying to knock out a bunch of unsecured debt. And you can see that disposable income is the debtor's monthly income minus the reasonably necessary expenses to support the debtor. And this would include, if it's done right, if a debtor is really savvy, they'll say, well, I can put this debt here, but I really need to do this reserves because I have capital improvements that will need to be made in 1 to 2 years to upgrade equipment or whatever. The benefit of that is if let's say that you as the lender are in the camp with the debtor of saying, yeah, we'd like to get this confirmed and shed a whole bunch of debt, then that disposable income may be really wise to work with the debtor and try to say, yes, you're going to need capital improvements down the road. You'll have to replace this equipment. So you need to factor that into your budget. And then whatever little bit remainder is left, that's what's going to go to the unsecured creditors. Well, you can see how people would play games with that, where the debtor may say everything's going to be needed, and so I'll just give this teeny bit of income to unsecured creditors. That's where you would get into an objection. And admittedly, you can get into a fight, but you see the tussle right there that gets into plan confirmation. Another issue is the feasibility. Is the debtor going to do it? Years ago, many, many years ago, here in the Western District of Missouri, there was a judge. Her last name was Judge C, S-E-E. And I have a partner who always likes to joke that it was the Judge C approach. Let's confirm the plan and see if it works. And unfortunately, there are definitely bankruptcy judges that are out there. And if you're going to challenge feasibility, the debtor has to come in and they can't just make these pie in the sky projections and get it confirmed. It has to be grounded in reality. But admittedly, there's going to be that tussle. Is this feasible or not? And if it's within the realm of reasonableness, judges tend to confirm it. So recognizing that and recognizing that you might not be able to win on the feasibility front, what you may need to do is then make sure that the plan builds in all the appropriate remedies. What if they default, right? Can we proceed to foreclose on our collateral? And that's where you want to, if at all possible, try to integrate your loan documents with the plan so that maybe, we don't like it as secured lenders to have the debt payment stretched out or whatnot. And unfortunately, debtors can do that. But what we want to do is maybe they tweak a couple of these key terms, but we want to try to keep all those other default remedies in place so that we can protect our position, if at all possible, when things go south. Best interest of creditors, basic question is, how are they faring here? That would be another way to challenge it. I see I'm way over time. You can't discriminate unfairly. It's another basis to challenge the plan. Here's my final comment, and we'll end this for today. When I was preparing for this, I kept having this image or idea come to my mind of, imagine you're sitting in the cockpit of a plane. You have all these different buttons, and those buttons all play an important role in different scenarios. And what we've tried to do here is we've basically shown you a lot of different buttons, but admittedly, in different scenarios, you're not going to be flipping some of those buttons in order to, try to fly this plane safely. It is very, very case specific. It is very, very unique to each situation. But the guiding principles here are get in, get involved very early, try to be very proactive in your negotiations. And if you take this kind of forward-looking, we'll come in and negotiate, we'll be somewhat reasonable, but still, very much press for our position. Those tend to be the situations that, at least in my experience, tend to work out best overall for the lender. So, Jana, that's all I have for today. Do you have any parting comments before I read these closing script items?
I don't, Michael, but I agree with you. It's important to be proactive and also work with the Subchapter 5 trustee. They do have a lot of pull with the debtors and can be your advocate.
Yep. All right. So, folks, thanks for joining us today. We hope that this was helpful. Obviously, you have our contact information if you need to follow up with any questions. As a reminder, this program has been approved for legal education hours. To report your hours, you click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Please be sure to complete our short survey at the end. We really value your feedback and really take it into account as we're looking at future programs. And this concludes our webinar for today. Thank you very much.